Good morning, everyone. I'm going to call the Corrections Policy Committee meeting for August 13th to order. We're at DPSST in the boardroom. I will read a public announcement. This is a public meeting subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by the Corrections Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. We will go to introductions, please.
When I call on you, please state your name and your representing for the record, please. Chair English.
Matt English, Oregon State Sheriff's Association, Hoover County Sheriff.
Member or Vice Chair Cameron.
Jennifer Cameron, Non-Management Parole and Probation, Lynn County Parole and Probation.
Member Aldridge.
Josh Aldridge, Oregon State Sheriff's Association Jail Command Council, Jackson County Sheriff's Office.
Member Boren.
Mark Boren, public member.
Member Bowden.
Margo Bowden, Non-Management Corrections.
Member Frasco.
Lori Frasco, Oregon Department of Corrections, and AFSCME.
Member Frost. Member Frost, can you hear us?
Oh, sorry. Yes, I can hear you. John Frost, Department of Corrections, non-management security representative.
Thank you. And then Member Hartford.
Mike Hartford, Oregon Association of Community Corrections Directors, Marion County Sheriff's Office.
Member Hunter.
Nick Hunter, Marion County Sheriff's Office, Oregon State Sheriff's Association.
Member Langley.
Ted Langley, representing OSSA Jail Command Council.
Member Mays.
Officer Mike Mays, Oregon Department of Corrections, represented.
And then Member Reese is not present. Member Reyes.
Aaron Reyes, Superintendent, Two Rivers Correctional Institution, representing the Oregon Department of Corrections.
Thank you. And then Member Tabor is also not present. And then for staff introductions, I'll go first. Juan Lopez, Executive Assistant, DPSST, and then to my left.
Shelby Red, Executive Assistant, DPSST.
Eric Riddell, Criminal Justice Support Specialist, DPSST.
Jennifer Lavario, Professional Standards Compliance Coordinator, DPSST.
Melissa Langbacho, DPSST, Professional Standards Compliance Coordinator.
Phil Castle, DPSST Agency Director.
Kathy Fink, DPSST.
Catherine Kalpine, DPSST.
Cindy Park, DPSST.
Jennifer Howell, DPSST.
Sam Kearney, DPSST.
And Bill Steele, Interim Deputy Director, DPSST.
Great, thank you. So this is our first meeting where there's been a few minor changes to the way that we're going to present and deliberate cases, and there's been some changes to voting, and the first one is coming up. So our meeting minutes, we used to do a vote on the minutes, and that'll be a consensus item. So has everyone had a chance to review the minutes from our previous meeting in May? Are there any modifications or issues with those minutes? If not, looking for consensus to approve the minutes. Thumbs up, thumbs down?
Yep.
All right.
Approved.
Informal voting. One way or another.
Yeah. Okay. So we will move to administrative closures. Jennifer Lavario, I'll turn it over to you.
Jennifer Lavario for the record. Before we move to the administrative closures vote, I'd like to call the committee's attention to the administrative closure of Megan Chapman, which should be the first one in your packet. There is a slight change correction on page 2. the second full paragraph of page 2. The last sentence begins with Chapman. It should begin with complainant. That is a correction that we didn't get into the packet prior to it coming to you. So with that change would be the vote, if the committee is okay with that change to the administrative closure. So again, page 2 of Megan Chapman. Chapman should say complainant, the last sentence of the second full paragraph.
Mr. Chair, do you need a motion to accept that change? If so, I'll make a motion to accept that change.
Matt English for the record. I think we can just do it if there's consensus around. I think we just do it as we adopt or as we do the consent agenda. Do both cases. So, are there any questions or discussion regarding the administrative closures? If there aren't any, I would call for a motion to approve the consent agenda as presented.
Mark Warren for the record. I move to approve the consent agenda.
I think if we could say as modified.
As modified, excuse me. I move to approve the consent agenda as modified.
Thank you.
And Nick Hunter, I'll second that.
Thank you. It's been moved and seconded.
All right, we are voting on a motion to approve the administrative closures as modified. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Frasco.
Aye.
Committee Member Reyes.
Aye.
Committee Member Hartford.
Aye.
Committee Member Aldridge.
Aye.
And Committee Member Mays.
Aye.
Motion passed.
Thank you. Okay. Yep. We're going to move into our first case, which is Nicholas Alberts. And I believe Mr. Alberts is online. You will have, first the staff's going to present the case to us, but when it's your turn, you'll have 5 minutes to provide mitigation to the committee. And there are no questions allowed, and you'll be, you have to stay within that 5-minute time frame. So I will turn the case over to Melissa Langbacho.
Thank you, Mr. Chair. Melissa Langbacho for the record. The department opened a professional standards case to review the circumstances of Nicholas Alberts' separation from the Multnomah County Sheriff's Office. His separation involved a resignation during an internal investigation into his use of force and truthfulness in his reporting of an incident that occurred on April 6, 2021. The department presented Alberts' case at the May 2024 meeting, and the committee requested additional information about the Multnomah County Sheriff's Office, their management plan of the adult in custody involved in the use of force incident. The department obtained those records and provided that information in the packet. Just for the record, at the May meeting, the committee identified some aggravating circumstances that Alberts refused to submit a report after the incident, and he participated in a ethics class and use of force training prior to the incident. The department determined that Alberts violated the board's moral fitness standards and found that he intentionally omitted information from his reporting of the use of force incident, and then he harmed another person when he punched an adult in custody during the use of force incident without justification. And as previously stated, Mr. Alberts is here remotely to provide a verbal statement, and he's provided written mitigation in the packets for the committee to consider. Mr. Chair. Mr. Alberts, whenever you're ready, I have a timer here that will start. So go ahead and continue whenever you're ready.
Okay, thank you. Good morning. My name's Nicholas Halberts. So I appreciate your time and consideration on this matter. I voluntarily resigned from my position as a corrections deputy at the Multnomah County Sheriff's Office in May of 2022. I resigned due to personal reasons, and I wanted to be clear that this was not a resignation in lieu of termination. I left on my own accord. There are 2 violations being sought here today by DPSST. First, it's for omitting information. The board is attempting to state that I omitted information from the report, but this is completely false. I wrote the report approximately 10 weeks after the incident and wrote it based on my perception and memory of the event. I cannot add things to my report that I do not recall at the time of documentation. Furthermore, I knew that there was a recording of the incident, so leaving any information out is of no advantage of mine as it is. The board is also stating that I had different details in my unsubmitted major misconduct report that was written the day of, and the finalized report that was written 10 weeks later. These documents were at different times and had a substantial distance in between them. I would also like to note that when I wrote the finalized report, I did not have the unsubmitted major misconduct with me to refresh my memory, and I also didn't have notes of the event the day of. So I didn't have anything to refresh it except what I remember. I would also like to state one more time that I wrote only what I could recall and what I perceived from the incident, and I cannot add items I do not recall from the incident. This staff report does not come close to have the necessary facts to say that I left out information on purpose. Regarding the use of force, while looking over all the relevant information, I asked the committee to also consider that I gave the AIC multiple orders to sell in, that I attempted to escort the AIC into their cell with the use of another deputy, and that I only switched to physical strikes once I felt an imminent threat by the AIC. In addition, please note that once the use of force began, at the first opportunity, I backed away from the inmate to create separation. I called for backup, and I ordered the AIC to sell in one more time. On the aggravating circumstances section mentioned during the May 8th Corrections Committee, it was noted that I refused to write the report. The reason for the invoking of garrity rights, which I learned from the union that day, was based upon Multnomah County Corrections Deputy Association advice. McDuh felt that MCSO's handling of the situation was inappropriate and advised me not to write the report at that time. Regarding this decision, I was listening to an association that I trusted and believed knew these situations better than I did. I would also like to emphasize that on the day of, McDuh did not have the facts of the incident nor video evidence. They gave me that advice strictly due to the way MCSO was handling the incident, again, where they felt that it was inappropriate. It would be unreasonable to assume any wrongdoing on my part based upon McDuh's advice, as they did not have facts or video evidence. We're strictly going off MCSO's way of handling it. This case has been a stress on my life for over 3 years. We were hopeful to have this case heard last May. It got pushed back to November. In November, I was driving to Salem, received an email. It's getting pulled and pushed back once again. In May, I showed up to the meeting via Zoom. DPSST had the case for almost 2 years, and there was very little to say in the way of negativity. In fact, there were only 2 aggravating circumstances mentioned. One, the delay in writing the report that I spoke of, and then 2 is the ethics and use of force class. But this in itself is not a negative factor without other substance to show that I was unethical. After that, it was decided to push the meeting back one more time for a management plan. The management plan came back showing that I did not violate this management plan for the AIC at the time of the incident.
Okay, is that it, sir?
Oh, I'm sorry. Can you guys see me? It cut out from my end.
Yes.
Okay, I apologize for stopping. I was trying to fix that. Okay. It came back for a management plan. The management came back that did not violate any sort of management plan or policy at the time. After all that, I believe that is time that DPSSD closes this case. When looking over the findings as a whole, the incident should not rise to the level of questioning my moral fitness to remain certified as a correctional officer. I thank DPSSD for their time here today, and I look forward to any more dialogue on this incident.
Okay, thank you. All right, so this case we had heard in May and asked staff to gather more information. They were able to do that. That was included in this iteration for consideration. So we will now open the floor and we're looking for consensus on whether we have enough information to move forward with the case and adopt the staff report. So this is a change. This procedure is a change from how we were doing it before, where we just need consensus from the committee to adopt the staff report, or if we don't have enough information, we can ask staff to try to find that for us. So floor is open, discussion about adopting the record.
Mr. Chair, Eris, for the record, did I understand correctly that we need a consensus, not a vote?
Correct.
Okay.
Yes. Yeah, so if there are no objections, is there a consensus to move forward with this case? Okay, hearing no objections, we'll open the floor now for discussion about the case itself and identifying any aggravating or mitigating factors. Please remember to state your name and identify any of the aggravating and mitigating factors for the record, please.
Mr. Chair, I have a question. The statement that Mr. Alberts just gave, is there a transcript of that statement, or is that literally just a recording at this time?
Captain Cowboy, for the record, it's just his, it's a transcript now as we go. I believe he also submitted a written one as well?
It's on the back.
Yeah.
Yes, but I doubt if you read that verbatim. So we do have a written transcript in your packet, a written mitigation in your packet, and then what he provided today orally.
Thank you. I'll try and look there, see if I can find clarification to the point that I have.
Phil Castle, for the record, is also transcribed on Teams as he read it.
Mr. Director, are you referring to the letter that's transcribed on Teams as he read it, or the statement that he just made?
The statement he just made, Sheriff. Probably have to scroll back a little ways.
Or put it in transcript view.
Yeah.
You guys are using some technological words I'm not even familiar with. So how do I put it in transcript view?
I think the 3 dots under more, you can click and it says transcription. It should pop up under recording and transcription.
Sheriff, if it's not up, I don't think you can go back and look at it because it only does it as your video is playing.
Yep, I can now see you being transcribed, sir, but otherwise there's nothing in there. So
Correct.
you just answered that question. Mr. Chair, what I'll do is I will make my point for discussion here, if you'll allow me, and I think that will kind of maybe provide some clarification as to where I'm at. The statement just provided by Mr. Albers, he referred to writing his report from memory, and he made the statement that he knew that there was a video, so he wouldn't leave those things out. Going back to the letter that he previously submitted, I wrote the finalized report approximately 10 weeks after the incident. I wrote it based on my perception of the event and my memory of the event. I can't add things I don't recall at the time I'm documenting the event. Going to the interview of Mr. Albers, which is page 130 in the text of the book in volume 1, question is asked, I'm sorry, I didn't even think I've asked you yet, because I'm going to ask you later, have you watched the video before? I have so I watched the video about 10 weeks after the incident when I was writing my report. However, I did not study the video. I watched it once and then I wrote my report. So I would add an aggravating circumstance that the statement he made today, the statement he made in the letter, and the statement that he made while being interviewed are different statements.
Other aggravating or mitigating?
Mr. Chair, air variance for the record, I'd say an aggravating factor on this is we need to also include that this is revolved around an alleged excessive use of force on an AIC who he's responsible for the care and welfare of.
Other aggravating or mitigating?
Mr. Chair, air variance for the record, mitigating, I'm feeling there's not, from the statements given here and within our packet, that there's not a lot of responsibility for the behaviors and actions taken by the deputy.
So, did you mean aggravating?
Would that be aggravating? Aggravating.
That there was no, you're saying there was no responsibility?
I'm not hearing any responsibility or
accountability
for the conduct and behavior.
Melissa, would you read back what we have, please?
Yes. Melissa Langbottom for the record, from the main committee meeting I had, is aggravating that Alberts refused to submit a report after the incident, and that Alberts participated in 4 hours of ethics and use of force training prior to the incident occurring. And from today's meeting I have as aggravating that he gave different statements about what he put in his reports in 3 different contexts. The incident revolves around the excessive use of force on an adult in custody who Alberts is responsible for the care and welfare of. And Alberts didn't take a lot of responsibility or show accountability for his conduct or behaviors. Mr. Chair.
Thank you. Are there any other factors? Is there consensus on the identified factors? Seeing a lot of head nods in the affirmative. So we'll open a discussion about whether there are moral fitness violations. So we have the following options for the moral fitness violation findings identified in the staff report. We can affirm and accept as is, modify and make changes, or negate and remove all of them. So in this case, we have 2 allegations. So dishonesty by intentionally omitting information from the report, and then misconduct, harming another individual by punching an AIC during a use of force incident without justification. So I would call for a motion either to affirm, modify, or negate.
Mr. Chair, Aaron Reyes for the record. Motion that we move forward as is.
Okay, so motion on the floor to affirm. Is there a second?
Mr. Chair, Nick Hunter, I'll second that motion.
Thank you.
We are voting on a motion to affirm the moral fitness violations as written. Chair English?
Aye.
Vice Chair Cameron? Aye. Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mays.
Aye.
Motion passed.
Okay, so next, call for a motion whether we recommend that the board take action or no action in this case.
Mr. Chair, Nick Hunter, I would make a motion that the board take action in this case.
Okay, thank you.
Mr. Chair, Aaron Reyes for the record. I second that we take action.
Okay, thank you. Any further discussion on the motion that we take action? Hearing none.
We are voting on a motion to take action. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mays.
Aye.
Motion passed.
Thank you. So now we will be considering length of ineligibility period, and just a reminder, since we have affirmed the moral fitness violations of dishonesty and misconduct, there is 3 years to a lifetime for dishonesty and 3 to 10 years for misconduct. So I will open the floor for discussion and motion on recommended length of ineligibility to the board.
Mr. Chair, Aaron Reyes, I'm still trying to get in sync with this new process.
Ditto.
Okay, so are we discussing or are we making a motion to recommend?
Yes, it's a motion. So a discussion about what the recommended ineligibility period in
Okay,
this case.
so if I have like an opinion, I can state that opinion.
Yeah, so basically, you know, if you're gonna state a recommended length of ineligibility, just on the record, why you're recommending that.
Okay, well,
Please.
Aaron Reyes, for the record, I recommend 10 years for the reason of the dishonesty and for the assaultive behavior towards an adult in custody that he had the responsibility for the care of.
Okay, thank you.
The record, Mr. Chair, Nick Hunter, I will second that motion, change the language just slightly. The dishonesty and then also for the misconduct, which resulted in the harm to the AIC.
Thank you. Are you okay with the modification?
I couldn't have said it better myself.
All right.
Thank you, sir.
All right, so we have a motion and a second for a recommendation of tenure and eligibility period. Any further discussion? Hearing none?
We are voting on a motion for a 10-year ineligibility period. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Fresco.
Aye.
Committee Member Reyes.
Aye.
Committee Member Hartford.
Aye.
Committee Member Aldrich.
Aye.
And Committee Member Mays.
Aye.
Motion passed.
Thank you. Okay, Mr. Alberts, you're free to leave if you choose. We're going to move on to our next case, Fights, who I believe is here.
Yes, I believe he's online. Mr. Fights, can you hear us?
Yes, I can. Can you guys hear us?
Yes.
We can.
Thank you.
Okay, so Mr. Fights, when you're called on, you'll have 5 minutes to provide verbal mitigation. You have to remain in that 5-minute period, and there will be no time for questions or answers. It's just for your statement. And I will turn the case over to Jennifer Lavario.
Thank you, Chair English. Jennifer Lavario for the record. Excuse me. The department opened a professional standards review after receiving information that Milan Feets was cited for driving under the influence of alcohol, recklessly endangering another person, and open container on September 14th, 2022 in Hood River, Oregon. On September 23rd of 2022, Mr. Feets accepted a plea agreement for a diverted sentence, which dismissed the recklessly endangering another person and open container charges. On December 12th of 2023, Mr. Feets completed his diversion program and the DUI was dismissed. Mr. Feets is currently employed with the Oregon Department of Corrections at the Eastern Oregon Correctional Institution. The department's review determined Mr. Feets did violate the board's moral fitness standards as follows. Misconduct: Mr. Feets violated criminal law by driving under the influence of intoxicants with a passenger and an open container of alcohol in the vehicle. Mr. Feets' conduct threatened harm to his passenger as well as other drivers on the road. Chair English.
We'll turn it over to Mr. Feets for your mitigation. So whenever you're ready, you'll have 5 minutes.
Okay. Well, I would like to start by saying hello, everybody. I'm Milan Fitz. And I'd like to say that I do acknowledge and accept actions and understand that my mistake that I've made in the past is not a reflection of my current values and ethics. I believe I went through the proper notification process by contacting my employer, which was Mr. Pedro at the time, Assistant Superintendent. If I made a mistake in this process, I will and accept that the Oregon Department of Corrections has been and continues to be a great career, and I wouldn't purposely put my employment in jeopardy. If I have misunderstood the proper notification process, I apologize. Since this incident, I've been working and focusing on myself by establishing new and healthy habits, creating and maintaining a healthy relationship with my kids and family. And it's a mistake that will never happen again. I strongly do believe that redemption is something to acknowledge, and the only people who can be redeemed are those who have done wrong, which was obviously me. This career means a lot to me. I worked so hard to get to where I am, 18 years. And I have family to support, and so that's pretty much all I got.
Okay, thank you. So, does the committee believe we have enough information to move forward with this case? If so, I'm just looking for consensus to adopt the staff report as presented. Seeing consensus in the room. So we'll open the floor for identifying any aggravating and mitigating factors in this case. Just remember to state your record, or state your name for the record, please.
Mr. Chair, Josh Aldrich for the record. Aggravating factor in this case is that Mr. Feet's conduct was a violation of criminal law.
Thank you.
Jennifer Cameron, for the record, mitigating factors. He did complete his diversion program, which in turn dismissed the criminal case, and there is no conviction. Also, mitigating is that it appears he has accepted responsibility for his actions and admitting that he was wrong.
Matt English for the record, just building on what Member Cameron said. Today during Mr. Feets' mitigation, he talked about supports that he has in place, the importance of the career and understanding that he made a mistake and is owning that. Additionally, I would say at the time of the arrest, he was really cooperative and essentially admitted to the officer that it was the correct choice to arrest him. Other aggravating or mitigating? Jennifer, could you read back what we have so far, please?
Yes, thank you, Chair. Jennifer Lavario for the record. For mitigating, I have he completed his diversion, which dismissed the case so there's no conviction. He accepted responsibility and admitted he was wrong. In his verbal mitigation, he pointed to supports he has in place and the importance of his career, that he made a mistake and owned that mistake. Also mitigating that at the time of his arrest, he was cooperative with law enforcement and admitted to the officer who was arresting him that this was the right thing to do to arrest him at that time. Aggravating, only one I have is that he violated criminal law.
Thank you. Any other aggravating or mitigating?
Ted Lang for the record. I would add to, I appreciate in Mr. Feet's statement, he stated that he's worked at building his career, and his career is for a long time, and his career is very important to him. And he made a statement saying that he wouldn't purposely jeopardize his career. However, I think that it needs to be recognized also that deciding to drive while intoxicated is a purposeful decision, and with his lengthy career, he should have known that it could jeopardize his career. So I think in that case, that's an aggravating circumstance as well.
Thank you. Any additional?
Marty Wogan for the record. Was aggravating with the fact that when asked if he'd had anything to drink, he had said that he did, but it was earlier. And he'd asked him if he had anything to drink while he was there. He said no. But when he told him what his blood alcohol level was, he said, I figured it would be, knowing that it was going to be 3 times the legal limit. So.
Thank you. Any others? Is there a consensus from the committee on aggravating and mitigating that have been identified? Right, seeing that we have consensus, so open the floor for discussion about moral fitness violations. So staff has identified misconduct in this case. So discuss and entertain a motion for affirming that misconduct, modifying and making any changes, or negating that factor.
Ted Lang for the record. I'd vote that, or I'd move that we affirm the moral fitness violations as they were prepared.
Thank you. So there's a motion on the floor to affirm the misconduct as identified.
Mr. Chair, Aaron Reyes for the record, I second his motion to move forward as it is.
Thank you. Any further discussion?
Right, we are voting on a motion to affirm the moral fitness violations as presented. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Frasco.
Aye.
Committee Member Reyes.
Aye.
Committee Member Hartford.
Aye.
Committee Member Aldridge.
Aye.
And Committee Member Mays.
Aye.
Motion passed.
Thank you. All right, the floor is open now for discussion and motion on whether we recommend to the board to take action or no action in this case.
Dick Hunter, Mr. Chair, I'll make a motion that based on the mitigating factors that have been presented in this case, that the board take no action on this.
Thank you.
Mr. Chair, Aaron Reyes for the record. I second the board take no action.
Thank you. Any further discussion? All right, we'll be voting on a motion to recommend no action in this case.
Voting on a motion to take no action, Chair English,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Warren,
Aye.
Committee Member Bowden,
Aye.
Committee Member Frost,
Aye.
Committee Member Hunter,
Aye.
Committee Member Langley,
Aye.
Committee Member Frasco,
Aye.
Committee Member Reyes,
Aye.
Committee Member Hartford,
Aye.
Committee Member Aldrich,
Aye.
and Committee Member Mays.
Aye.
Motion passed.
All right, thank you. Thank you for being here today, Mr. Fights. You're free to go.
Thank you very much.
All right, we are going to move to the last case that we have in Volume 2, which is Luis Babanco, who is present today on Teams.
Yes, sir.
Can you hear us okay?
Yeah, can you hear me?
Yes. Okay, so when it is your turn to speak, you will be given 5 minutes to provide mitigating information for us to consider. That 5 minutes is timed, and there will be no time for questions or answers following. So I will turn the case over.
Thank you, Chair. Jennifer Lavario for the record. The department opened a professional standards review after Luis Babanco was hired by the Oregon Department of Corrections on March 5, 2024. Prior to his hire date, Mr. Babanco had been terminated from the Oregon Department of Corrections for being untruthful during his background investigation and falsifying his F5 DPSST Academy training application. Mr. Babanco failed to report his criminal citation occurring in January of 2020 for theft 3 to DPSST and failed to report the alias he used when cited for theft 3 to the DOC background investigator during his hiring process. At the time of Mr. Babanco's termination from DOC on August 29th of 2023, Mr. Babanco had not been certified by the DPSST, therefore the case was deferred. When Mr. Babanco was rehired by DOC on March 5th of 2024, DPSST obtained jurisdiction to review the case, which is why it is before the committee now. The committee will be determining whether to deny Mr. Babanco's certification. The department's review determined Mr. Babanco did violate the board's moral fitness standards as follows. Mr. Babanco was intentionally dishonest by omission during his background investigation with DOC when he did not disclose an alias he used when cited for theft 3 in January of 2020. Mr. Babanco was intentionally dishonest when he provided misleading and contradictory statements about his reason for marking no on his F5 application for training to DPSST and the DOC investigator. Mr. Babanco was intentionally dishonest when he provided an alias during his criminal investigation for theft 3 in January of 2020. Mr. Babanco falsified his F5 application dated October 17th of 2022 when he marked no to question 10, criminal history. Mr. Vivanco was criminally cited for theft 3 on January 4th of 2020, a Class A violation, and convicted after pleading guilty on January 30 of 2020. Mr. Vivanco, are you ready to provide your mitigation?
Yes, I am.
All right, you have 5 minutes, beginning now.
With my criminal history, I was in high school at the time, and it was a terrible mistake I made. I do deeply regret it. During that hearing in court on January 30th, I did end up giving my alias up to the judge and setting the record straight. However, with the background check with the DOC, I did negate information. It was nothing. I had other background checks with other jobs, and it was never an issue that rose up. So I just tended to forget about it. And with working at the DOC, it has helped me understand how vital integrity and just forthcoming is, especially with the population we work around. We're trying to set the better example. As far as being contradictory with the interview, that was later on. I was about 10 months into my year, and I was having troubles recalling if I did if I did say certain information or if I didn't. And it was kind of hard to recall under my year with the Green Book and the BCC class finally being over and all that stuff. I do want to say that I do apologize deeply for the time that I'm taking up and all the misdoings I have done. While I've worked with the DOC and when I was rehired, I did put all my information on this background check, everything. And I do want to say that I also have had no complaints from my management or other staff. I do have good evaluations, and this is a deep passion for me. I look to take care of my family with this career, and I look to just get better every day and try hard to make something of myself through this career and this profession. And I know I made my mistakes, and it's just, I wish I could go back and change those mistakes and, do the right thing. But this is where I'm at right now, and I would like a second chance to continue my career and develop and become a better correction officer. And I'd say that's all I have to say right now.
All right, thank you. Okay, so floor is open. Just checking to see if there's consensus in this case to adopt the record, or if we need to return it for more information before we move forward. Seeing consensus, not hearing any objections. So open up the case for discussion for any aggravating and mitigating factors.
Chair Nick Hunter for the record, aggregating factor, and I don't want to get the name wrong here, so I'm going to use Luis because I'm not going to pronounce the last name incorrectly. Multiple opportunities between the forms for DPSST and the background investigation itself to provide the truth regarding his citation arrest in 2020, and aggravating that throughout all of those opportunities, he continued not to share that information.
Mr. Chair, Aaron Reyes for the record. Aggravating is Mr. Vivanco did sign his F5 Academy Training Application Form on 10/17 of 22, where he attests that all the information is accurate, and I think it's an aggravating factor.
Mr. Chair, Josh Aldrich for the record. Aggravating factor is the recency of this event, only being approximately 2 years ago that this deceptive signing and form completion occurred.
Mr. Chair, Aaron Reyes for the record, an aggravating factor is Mr. Vivanco did commit the crime of theft 3 and pled guilty to it. I'm sorry, was arrested, pled guilty to, and convicted of theft 3. My apologies.
Mr. Chair, for the record, Nick Hunter, aggravating factor, the use of an alias during that arrest itself.
Matt English for the record. As confirmed today through the mitigation statement, there are multiple instances of dishonesty. The arrest in 2020 where he used the alias and then the falsifying records during the pre-employment, so it's not a one-time dishonesty.
Mr. Chair, Josh Aldrich for the record. A mitigating factor, I think, in this case is that Luis is now taking accountability for it. So I think it's important that we document that.
Mr. Chair, Nick Hunter, one more aggravating factor, and it piggybacks on that statement of accountability, referring to the letter that Luis wrote to DPSST, third paragraph. I take full responsibility for the confusion that I caused and deeply regret any inconvenience it may have resulted in. Using the word confusion in there is not taking responsibility. That is just simply mitigating what happened.
Mr. Chair, Aaron Reyes for the record, a mitigating factor, I'm not sure if this is permissible or not, but in looking at the investigation done by the Oregon Department of Corrections, there were 2 allegations of dishonesty which were both substantiated by the investigator.
Aggravating or mitigating?
I would say that's aggravating. Thanks for the help.
Jennifer, can you read back what we have so far?
Sure. For mitigating, I have Luis is now taking responsibility or accountability for his actions. For aggravating, I have there were multiple opportunities for him to provide the truth about the theft 3, but he continued to not provide the truth. He did sign the F5 on 10/17/22 and attested that the information on the F5 was true. The recency of the event and the deception was an aggravating factor. He did commit the crime of theft 3 and pled guilty and was convicted. His use of an alias during the arrest itself, the multiple incidents of dishonesty, including the alias, the F5, the background investigation, his letter to DPSST, in which he used taking full responsibility for confusion. The word confusion is not taking responsibility. And then DOC's substantiation of 2 allegations of dishonesty during their investigation was aggravating.
Thank you. Is there any additional aggravating or mitigating in this case? Is there a consensus on what has been identified so far?
Yeah.
Okay. So we would move into discussion about, discussion and a motion. Whether there are moral fitness violations in this case, so we can affirm, modify, or negate what staff has identified. Staff's identified dishonesty and misconduct in this case.
Mr. Chair, Aaron Reyes for the record, and that we confirm as is.
Thank you. Is there a second?
Margaret Bowden for the record, second that.
Thank you. Further discussion? All right, Erica.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mace.
Aye.
Motion passed.
Thanks. Okay, the floor is open now for a motion to recommend to the board whether they take action or no action in this case.
Mr. Chair, Josh Aldrich for the record, based on the aggravating mitigating circumstances listed, I recommend that the board take action.
Ted Langley for the record, I'd second that motion.
Thank you. There's a motion, recommend action by the board. Further discussion? Thank you.
We are voting on a motion to take action. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mace.
Aye.
Motion passed.
Thank you. All right, the floor is now open for discussion in motion about recommended length of ineligibility. Because this case includes dishonesty, it can be anywhere from 3 years to lifetime recommendation.
Mr. Chair, Aaron Reyes for the record. For discussion, I'm going to move for a 10-year revocation.
And so there's been a motion to recommend a 10-year revocation in this case.
Jennifer Cameron for the record. While I certainly dishonesty is an issue, Luis is, right? Yes, the crime that he committed was when he was young. People do have bad judgment calls. I'm not making excuses for him. He was terminated from DOC during the probationary period and has since been rehired. I moved for a 3-year 3 years.
Oh, Matt English for the record. So we have a motion on the table for a 10-year. If there's not a second, then we move forward with another recommendation.
Aaron Rice, for the record, I second. I could get behind a 3-year.
Okay, so we'd have to remove the first. If there's no second on the tenure, then that motion would die, and I haven't heard a second on that. And so now on the table is a recommendation for a 3-year ineligibility period, and understanding there'd be a second for that.
Yes, sir. There'd be Aaron Rice, for the record. I second the 3-year.
Okay, so there is a motion for a 3-year ineligibility period recommendation to the board. Any discussion on that before we vote?
We are voting on a motion for a 3-year ineligibility period. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mays.
Aye.
Motion passed.
Okay, thank you for your time today, Mr. Vivanco.
Thank you.
Yeah. Okay, we are going to move to Mark Ballum, and is here in person, so we'll wait till he comes in the room. And that would be case number 1 in volume 2.
Right? Yeah, there's only so much nowadays.
Hello. Good morning. Can you pronounce your last name for me so I get it correct? Please?
Malum, sir.
Malum?
Yes, sir.
All right, thank you. So, Mr. Malum, in a minute, you will be given time for, you'll be given 5 minutes to provide verbal mitigation. It will be timed by DPSST, and there are no questions or answers after that time. So I will turn the case over to Jennifer Lorio for presentation, please.
Thank you, Chair English. Jennifer Lavario for the record. The department opened the professional standards review after receiving information that Mark Malum was criminally cited for driving under the influence of intoxicants on June 19th of 2022 by the Myrtle Point Police. On June 21 of 2022, Mr. Malum received a criminal citation for hit and run and criminal mischief in the second degree by the Oregon State Police after a citizen discovered damage to a portion of his fencing. The Coos County Sheriff's Office responded to the scene of the damage and was able to link it to the DUII on June 19th of 2022. The Coos County DA, having received the full investigation for both incidents, charged Mr. Malum with DUII, reckless driving, and failure to perform the duties of a driver with property damage. On September 20 of 2022, Mr. Malum pleaded guilty to DUII and the charge was diverted. The reckless driving and failure to perform the duties of a driver property damage were dismissed. On August 1 of 2023, the DUII was dismissed after Mr. Malum completed the conditions of his diversion. Mr. Malum is currently employed with the Coos County Sheriff's Office. The department's review determined Mr. Malum did violate the board's moral fitness standards as follows. Misconduct. Mr. Malum violated criminal law when he received a criminal charge of DUII, reckless driving, and failure to perform the duties of a driver property damage. Mr. Malum threatened harm to persons and property by driving under the influence of alcohol, hitting a fence, dragging it down the road under his vehicle. Mr. Malum, are you prepared? Are you ready for your statement?
Yes, ma'am.
All right, go ahead.
My name is Mark Malum. I've been in law enforcement for approximately 15 years. I've always strived to be the best man I can for my family, my community, and my career. I failed miserably on the morning of June 19th, 2022, when I made the terrible decision to drive under the influence of alcohol, and was ultimately stopped by Officer Gilbert of the Morro Point Police Department, preventing many possibilities from occurring. There's not a day that goes by that I do not fully recognize how the outcome of my actions could have resulted in far worse than the situation I put myself in here today. Words cannot express how truly grateful I am for Officer Gilbert's intervention that morning. I believe that my decision to drive that day was the worst decision that I've ever made. Knowing that I put myself and others in such great risk of harm is something I will forever regret and never forget. And it is a position I will never put myself in or others ever again. The shame and remorse that I feel for my decision the morning of June 19th, 2022 has stayed with me and will never be forgotten. However, my eyes have been widely opened. I have been humbled, and I'm more grateful for the growth in myself that has taken place since that day. I've had to take a giant step back and take a good look at myself and my behavior. I have decided to quit drinking, not for myself and my family, but for my career as well. I've embraced treatment, and with the love and support of my family and the Coos County Sheriff's Office, I have not had a drink in over 2 years. I am dedicated to the life of sobriety, honor, and integrity. While I give much credit to my family and colleagues, I also found my treatment classes through ADAPT, our local drug and alcohol treatment provider, to be helpful and insightful. As a deputy sheriff, I often hear of people who are required or even choose to attend treatment, but I knew very little about it. While it was quite humbling, it provided me with an understanding of myself and the reasons that I abuse alcohol that I will likely never have understood on my own. I graduated the program over 1 year ago, but still utilize the skills that I have learned for a lifetime. Throughout treatment, as well as my living sober lifestyle, I have acquired healthy coping skills to address future stressors and events as a sober individual. Strangely enough, I have become very grateful for this terrible event. If there were a way to take it back, I would certainly do that, but since that is not possible, I have chosen to make a bad decision an opportunity to improve myself. Since becoming sober, I have realized how much the quality of my relationships have improved as a result. My wife, my children are closer to me than ever before, especially after being married for 30 years. I feel that it is quite an accomplishment. I also feel that the quality of my work performance have improved. While I've always taken great pride in my work, I believe the self-discipline that I learned as a young Marine has been rejuvenated. and as a result is more attention to detail and more accurate assessment of myself, teammates, and situations. Today I look myself in the mirror and I like who I see. I am confident that I'm an excellent public servant and a credit to my profession. I feel that I'm an asset not only to my department and partner agencies, but to the public who I work for. While I will never forget my mistake, I can only look forward, and it is my sincere hope that I'm allowed to continue to serve my community. That is all I have.
Thank you. So is there consensus from the committee to adopt the record as presented by staff?
Yeah.
All right, so the floor is open for discussion of aggravating and mitigating circumstances in this case. Start Matt English, for the record, aggravating the BAC that was almost that was 2.5 times the legal limit, and also the fact that the DUI resulted in a crash and property damage that wasn't recognized by Mr. Mullen until he was stopped. And then also mitigating Mr. Mullen's presence today, his accountability for his actions, the steps that he's taken since that incident. Also, I would note that he has support from his agency. There's a letter from Sheriff Fabrizio, and Sheriff Fabrizio is here in the room today, as well as jail commander and another friend that were in our packet.
Mr. Chair, Aaron Ricks, for the record, mitigating factor would be he's gone above and beyond the steps to improve himself to assure that this mistake is not repeated.
Ted Langley, for the record, in his verbal mitigating statement today too, I think it's important to recognize that he spoke about not just the impact on his career, but he recognized impact on his own family and the people that ultimately support him. And I think that's an important recognition to make as well.
Chair Nick Hunter, mitigating following the incident, Mr. Mullen did take it on his own accord to go try and find the location where the damage had occurred. And once he was able to establish that location through the help of the investigation, he did go to that property owner and essentially make that situation right, which was then solved under a civil compromise.
Mr. Chair, Mike Hartford, for the record, aggravating. This is Malem's second DUI charge in the state of Oregon. On April 29, 2004, he also was criminally charged and entered into a diversion program. So while his statements about opening his eyes this time, he was afforded an opportunity previously. Thank you.
Jennifer, can you read back what we have thus far, please?
Yes, thank you, Jennifer Lavario, for the record. For mitigating, I have his presence today and the accountability he's taken for his actions. For mitigating, the steps he's taken since this last DUI are mitigating. Support from his agency, with Sheriff Rabazio and others here supporting him, speaks to a mitigating circumstance. He went above and beyond the steps needed to move forward and improve himself. He spoke to the impact to his career, but also to family and the people who support him. Following the incident, he tried to find the location of where the damage occurred, and when he did, he made the situation right through a civil compromise. Aggravating, the BAC in the second DUI was 2.5 times the legal limit. There was property damage, which wasn't recognized until later. Mr. Malum's second DUI charge, in which he had an opportunity at that first DUI to make changes, which he didn't appear to do.
Thank you. Any other aggravating or mitigating? Is there consensus around what has been identified thus far? Seeing consensus, so I've opened the floor for discussion and motion, whether to affirm, modify, or negate the moral fitness violations that have been found in this case, and staff has identified misconduct for the criminal charge of DUI, reckless drive, and failure to perform duties of a driver property.
Nick Hunter, Mr. Chair, I would make a motion that we accept the staff findings as they are, highlighting misconduct.
Thank you. There's a motion to affirm staff recommendation or staff findings of misconduct.
Ted Langley for the record, I second that motion.
Thank you. Any further discussion?
We are voting on a motion to affirm the moral fitness violations as presented. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Frasco.
Aye.
Committee Member Reyes.
Aye.
Committee Member Hartford.
Aye.
Committee Member Aldrich.
Aye.
And Committee Member Mace.
Aye.
Motion passed.
Thank you. The floor is now open to call for a motion to take action or no action recommendation to the board in this case.
Mr. Chair, Aaron Reyes, I move we take no action on this case.
Thank you. There's a motion to recommend to the board no action in this case.
Chair Nick Hunter, I will second the no action based on the mitigating circumstances that were provided in this, acknowledging the aggravating circumstances, but really highlighting the mitigating. And Mr. I'm going to say it wrong too. So Malham's presence in the room today and his statement that he provided.
Thank you.
We are voting on a motion to take no action. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Frasco.
Aye.
Committee Member Reyes.
Aye.
Committee Member Hartford.
Aye.
Committee Member Aldrich.
Aye.
And Committee Member Mays.
Aye.
Motion passed.
All right. Thank you, Mr. Mullen. You're free to go.
Thank you very much for your time.
Okay, we're going to move next to the second case in Volume 2, Ryan McCone, who is also here, so we'll wait for him to come in. Watson. Welcome. All right. Mr. McCone, is that how you pronounce your last name?
Yes, sir.
Thank you. Okay, so when we turn the floor over to you, you will have 5 minutes. That is time to provide your mitigating statement, and there is no questions or answers afterwards. I'll turn the case over to Jennifer Lavario for presentation, please.
Thank you, Chair. Jennifer Lavario for the record. The department opened a professional standards review after receiving information that Ryan McCone was criminally cited for hunting game birds over a baited area, which is a misdemeanor, on March 10th of 2022. On December 7th of 2022, Mr. McCone entered a plea of no contest to the district attorney's lesser charge of taking, angling, hunting, or trapping in violation of wildlife law or rule, a Class A violation, and was convicted. Mr. McCone was fined $750. Mr. McCone is currently employed with the Washington County Sheriff's Office. The department's review determined Mr. McCone did violate the board's moral fitness standards as follows. Mr. McCone violated criminal law by pleading no contest to taking, angling, hunting, or trapping in violation of wildlife law or rule after being criminally cited for the misdemeanor charge of hunting game birds over a baited area. Are you prepared? Ready? Okay. Go ahead.
Okay. I did type something out just so I wouldn't miss any points, as obviously it's kind of a nervous situation. So, good morning. My name is Ryan McCone. I'm a deputy for the Washington County Sheriff's Office in the Jail Division. I want to thank you all for allowing me to speak in front of you today. Working in law enforcement for the past 17 years. I've always held myself to a very high standard on the job in my personal life. And in 2022, I found myself getting in trouble because I hunted a cornfield and another hunter had baited with corn on that field. I had no knowledge of him doing this, and that information was in the trooper's report. Unfortunately for me, the Fish and Wildlife regulations state that a person should reasonably know. Therefore, I was held accountable for as well, because I should have looked over the field before I was hunting. As you can imagine, this was a very stressful time in my life. I was very forthcoming with all my information I had with the trooper, the sheriff's office, and is very well supported with from my fellow deputies and administration as well. In the end, I accepted a violation and a small fine, which I did pay promptly. In regard to the sheriff's office, I was given a 1-day suspension of unpaid leave and thankfully got back to work. For the last 18 months, I've been back to work and my life has gone back to normal. Sorry. Though this is a very stressful career and we're extremely short on staff, I still enjoy my work and feel like I can help people better themselves. Over the past 17 years working in corrections, I've never been in trouble. If you can see my file, I have nothing but positive performance observations and life-saving awards from my peers, which I take great pride in. I've been a field training officer for nearly a decade as well, and I've trained some amazing deputies. I hope you allow me to keep my certification and keep my passion for working in law enforcement a reality. For the last couple months, I married an amazing woman. We bought a farm together, and my parenting plan with my children has gotten better where I can see my kids more. If I lose my certification, I'd most certainly lose my time with my kids. And I'd not be able to afford the farm that we just got. I've dedicated my entire career to law enforcement. And I'd like to say that I accept the responsibility of what I did, even though it wasn't on purpose. You know, I accepted the violation in court, which is hard, you know, because I have a clean record. And I'm very apologetic to that, because working in law enforcement, we're held to a higher standard on and off the job. And I did not follow that as much as you want to say by getting in trouble. So I do apologize for everybody in the law enforcement career, because we are held to a higher standard. So I'm apologetic for that very much, and I'm remorseful for what happened. I only hold myself accountable for it. That's why I accepted the violation, because I think self-accountability is what we need to do in this career. And I'm very more aware of the hunting regulations. Wasn't quite aware that I could get in trouble for something like that. So that was also my responsibility as well. And I just wanted to apologize for everybody. And I just hope you allow me to keep my certification. I love working in law enforcement. It's a very stressful career. And like I said, we're very short on staff. And I love teaching new deputies. And I just want to keep my career and go forth and better myself. And I hope you guys make that choice, but that's up to you. I just want to say I was sorry, and hopefully this will be the end of this and I can get back to my normal life. So that's all I have to say. Thank you.
All right, thank you. So is there a consensus from the committee to adopt the staff report as presented to us, our folks? All right, seeing consensus, I'd open up the floor for discussion to identify any aggravating or mitigating circumstances in this case. I'm adding those for the record. Say mitigating, Mr. McCone pled guilty to this violation and today has admitted his mistake and owned it. I think also mitigating was his emotion around the mitigating statement. I think it's very sincere what he presented to us today and the importance of his of this career to him.
Mr. Chair, Josh Aldrich for the record. Mitigating circumstance additionally, while Mr. McCone acknowledges that it was probably his responsibility to know what was happening in the field they were hunting in, there's no indication in the staff report that he was aware that the field had been potentially baited.
Any other aggravating or mitigating? Jennifer, will you recount what we have thus far, please?
Thank you, Chair. Jennifer Lavario for the record. I have no aggravating circumstances. Mitigating, he pled guilty and admitted his mistake. There was a motion around the statement he gave today, which indicates the importance he places on the career. And there was no indication in the staff report that he was aware the field was baited.
Thank you. Any other aggravating or mitigating?
Mr. Chair, Aaron Reyes, I feel for the record we should at least report on aggravating that we're here today because there was a fish and wildlife charge.
So a criminal charge?
A criminal charge, yes, sir.
Any other aggravating, mitigating? Is there a consensus around what we have identified thus far? Could I open the floor then for, seeing that there's consensus, I would open the floor for a motion to accept, modify, or negate the moral fitness violation as identified by staff, which is in this case misconduct, for the criminal charge of taking angling, hunting, or trapping in violation of wildlife law or rule.
Ted Langley for the record. I'd make a motion that we affirm the moral fitness violations as they were prepared.
Thank you.
Mr. Chair, Aaron Reyes, I second his motion.
Thank you.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Chair English,
Aye.
Vice Chair Cameron.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Frasco.
Aye.
Committee Member Reyes.
Aye.
Committee Member Hartford.
Aye.
Committee Member Aldrich.
Aye.
And Committee Member Mays.
Aye.
Motion passed.
Thank you. Floor is open now for recommendation to the board to take action or no action in this case.
Mr. Chair, for the record, Mike Hartford, I make a motion and recommend no action be taken in this case.
Thank you.
Jennifer Cameron for
Mr.
the
Chair.
record. Jennifer Cameron for the record, I will second the motion. I think his crime ended up being a violation. He is sincere in where he's at, and I believe that moving forward, from what he said, he's going to make sure that he knows what's going on. And he's clearly a valued employee.
All right, any further discussion? If not, we have a motion to recommend no action.
All right, we are voting on a motion to take no action. Chair English.
Aye.
Vice Chair Cameron.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Frasco.
Aye.
Committee Member Reyes.
Aye.
Committee Member Hartford.
Aye.
Committee Member Aldrich.
Aye.
And Committee Member Mays.
Aye.
Motion passed.
All right, thank you, Mr. McClung, for your time.
Thank you, and I'm sorry once again for wasting your guys' time with this. Have a good day. Thank you.
Thank you. Yep. All right, we will move back to volume 1, the last case on that book, Tracy Huber.
Ready, Mr. Chair?
When you are.
Thank you. Jennifer Lavarno for the record. The department opened a professional standards review after learning Tracy Hubler had been arrested for driving under the influence of intoxicants and reckless driving on November 7th, 2022 in Astoria, Oregon. On April 20th of 2023, Ms. Hubler entered a plea of guilty to both charges as part of a diversion agreement. On May 3rd of 2024, a judgment for dismissal of both charges was entered into the Clatsop County Circuit Court after Ms. Hubler completed the conditions of the diversion program. Ms. Hubler is currently employed with the Clatsop County Sheriff's Office Parole and Probation Department as a parole and probation sergeant. The department's review determined Ms. Hubler did violate the board's moral fitness standards as follows. Ms. Hubler violated criminal laws when she was cited for DUI and reckless driving. Ms. Hubler threatened harm to persons and property when she drove her vehicle while under the influence of alcohol at 0.381% blood alcohol content and cannabis and crashed into a tree. Ms. Hubler was a parole and probation sergeant at the time of her criminal conduct, which brought discredit to the Clatsop County Sheriff's Office and undermined the public's trust in the law enforcement profession and the agency, thus harming the efficient operations of the agency. Chair English.
All right, thank you. So, do we have enough information? Is there consensus to adopt the staff report? Seeing consensus in the room, online, I would open the floor for discussion of aggravating and mitigating circumstances in this case.
Ted Langley for the record. In this case, I would list a couple of different things as aggravating circumstances. One was the excessive BAC that was taken during the event and the positive test for use of cannabis. As long as this person worked in law enforcement, I think an aggravating factor is that she should have been well aware of different resources and different avenues to get help for herself if she was having problems sleeping or if she recognized a substance abuse issue, which I think both of those things were outlined in the staff report that were provided. I will add, as mitigating, again, with the lengthy service history, it did appear that her service history was discipline-free, so.
Mr. Chair, Josh Aldridge for the record. Aggravating factor, again, just we are here because of a violation of criminal code.
Thank you. I'm adding this for the record. Mitigating, she provided written mitigation for our consideration. Additionally, she's outlined the steps that she's taken, has gone through treatment, admitted to her actions, and her sobriety for at least a year and a half now.
Mr. Chair, Josh Aldridge for the record. Mitigating factor, it appears she successfully completed all the elements of the court-ordered diversion.
Any other aggravating or mitigating in this case? Jennifer, can you recall what we have so far, please?
Sure, thank you, Chair. Jennifer Lavario for the record. Aggravating, the excessive BAC taken during the arrest, the use of cannabis, the positive test for cannabis, that Ms. Hubler should have been well aware with her years of service of the resources available for sleeping disorders and substance use disorders, and that it was a violation of criminal law. For mitigation, her lengthy service history, which was discipline-free. She provided written mitigation and outlined the steps she'd taken, including treatment, admitting her actions, and being sober for at least a year and a half, and that she successfully completed her diversion.
Thank you. Is there any other aggravating, mitigating in this case? Is there a consensus around what's been identified thus far? Seeing there is consensus, open the floor for a motion to affirm, modify, or negate the moral fitness violations as identified by DPSST, which are in this case misconduct for the DUI and cannabis, and harming the efficient operations of Clatsop County Sheriff's Office.
Nick Hunter, Mr. Chair, I'll make that motion to accept the report as identified by DPSST, highlighting misconduct in their findings.
Mr. Chair, Aaron
Josh,
Reyes. Second.
Thank you. It's been moved and seconded to affirm the moral fitness violation findings.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Chair English,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Boren,
Aye.
Committee Member Bowden,
Aye.
Committee Member Frost,
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley,
Aye.
Committee Member Frasco,
Aye.
Committee Member Reyes,
Aye.
Committee Member Hartford,
Aye.
Committee Member Aldrich,
Aye.
and Committee Member Mays.
Aye.
Motion passed.
Thank you. Floor is now open for a motion to recommend to the board action or no action in this case.
Mr. Chair, Nick Hunter, I'll make a motion that the board take no action in this case, largely based on the letter provided by Ms. Hubler and the steps that she's taken following this. I can hear the concerns on the other avenues that she should have known existed, but many in the room are familiar with addiction and what addiction can do, and what she's done following that with her mitigating circumstances. I would make that recommendation on no action.
Chairman English, John Frost, for the record, I'd second that.
It's been moved and double seconded. Thank you.
All right, we are voting on a motion to take no action. Chair English,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Boren,
Aye.
Committee Member Bowden,
Aye.
Committee Member Frost,
Aye.
Committee Member Hunter,
Aye.
Committee Member Langley,
Aye.
Committee Member Frasco,
Aye.
Committee Member Reyes,
Aye.
Committee Member Hartford,
Aye.
Committee Member Aldrich,
Aye.
and Committee Member Mays.
Aye.
Motion passed.
All right, thank you. So we have been at it for almost 2 hours and we still have several cases to go through. How about a 10-minute break?
Aye.
Aye.
Gonna mute us? I don't know.
Yeah.
Yes. Okay, we will move to our next case, which is the third case in volume 2, Nicholas Mitchell. We'll turn it over to Melissa has a case.
Thank you, Mr. Chair. Melissa Langbacha for the record. The department presented Nicholas Mitchell's professional standards case at the May CPC meeting. In the department's written report, the department indicated that if action was taken, then ineligibility period would be based on the date of his separation from employment. During the presentation of the case and discussion, the department indicated that the ineligibility period on the report was incorrect. It would be based on the date of his conviction. Following the committee meeting, the department continued to hold discussions about ineligibility periods and determining those. And for Mr. Mitchell in particular, it was determined that the February 17th, 2023 separation from employment would be the correct ineligibility period to calculate action timeframe for revocation of certification for him. So in the committee meeting in May, the committee voted to make a recommendation for 3 years of an ineligibility period, and the department is seeking a motion and vote to reaffirm the start date of the ineligibility period for his case, Mr. Chair.
Thank you. So, Matt English for the record. So, just for clarification,
yes.
the DPSST just wants confirmation that it's okay that because it's 6 months later, so this would run 6 months later, essentially.
Correct.
6 months.
Yes, that the extra time is okay. The other option would be for the committee to vote to take no action instead.
Matt English for the record. I remember this case and also remember the justification for seeking a suspension in this case because of the injury and the egregiousness of this case. So my recommendation, I would make a motion that we just reaffirm the 3-year with the correct starting date.
Ted Langley for the record. Can I ask for one point of clarification? So is it that something changed in the eligibility period, or was it just a mistake on informing the committee of when it would actually start? Or both?
So I think how we've each read which ineligibility period applies has sort of been confusing, and we finally came to a consensus on that. So there was a discussion about which, because it involved separation of employment and a criminal charge, which one of those would be the one that would come into play. I'm sorry, I forgot the second part of your question.
No, I think you answered it. So it wasn't a matter of that. The question was initially, was it a change in the actual ineligibility period, or was it just a change in the board's position in the report to the committee of which one would apply?
Sure.
So that's what I'm hearing.
Yeah, and I didn't think that DPSST had the ability to go forward with the wrong information and putting the wrong date in the report to the board. So we wanted to bring it back to the committee to make sure that we presented the correct information to the board.
Kath McAlpine for the record. To put a little more context into it, what goes behind the scenes is, I know that oftentimes the committee likes to know when they're deciding to take action, when does that ineligibility period start? Because we know it's a moving thing depending on the circumstances. And so when applying this, and it's a moving scale, right? Whether the criminal conviction happened before or after, while they're employed, did the separation. And once we found that there was about a 4-month gap, sometimes that's important to the committee when they actually think about when do we apply it and are very intentional on when they think that start date is, and only then ask for maybe the minimum. In this case, it's 3 years, you can't go lower. But it was worthy to come back and just make sure that that still stood, knowing that it would basically increase his eligibility period about 4 months.
Josh Aldrich, for the record, I would second the current motion to reaffirm using the new dates.
All right, we are voting on a motion to reaffirm the 3-year ineligibility period with the updated start date. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden? Aye. Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mace.
Aye.
Motion passed.
Thank you. Okay, we're moving on to our next case, Diego Saldana, presented by Jennifer Lavario.
Thank you, Chair. Jennifer Lavario for the record. The Department opened a professional standards review after receiving information that Diego Saldana was cited for driving under the influence of intoxicants on September 13th of 2022 in Umatilla, Oregon. The Umatilla District Attorney charged Mr. Saldana with DUI and reckless driving. Mr. Saldana entered a plea of guilty to DUI on January 1 of 2023, and the reckless driving charge was dismissed. Mr. Saldana entered into a diversion agreement for the DUI. He completed the diversion program, and the DUI charge was dismissed on February 12th of 2024. Mr. Saldana is currently employed with the DOC, Two Rivers Correctional Institution. Mr. Saldana's citation for DUI occurred before he completed his application for certification, so his certification is pending the outcome of this review. The committee is reviewing his criminal disposition because Mr. Saldana was employed in a certified position at the time he received the at the time he received the DUI citation. The department's review determined Mr. Saldana did violate the board's moral fitness standards as follows. Mr. Saldana engaged in misconduct when he was criminally charged with DUI and reckless driving. Mr. Saldana drove his vehicle while significantly impaired, which threatened harm to people and property. Chair English.
Thank you. If there are no objections, I move that there is consensus to adopt the record or the report as presented by staff.
Mr. Chair, Aaron Reyes, I'd like to report a potential conflict as the Officer Saldana does work for the Two Rivers Correctional Institution. He does work for me, and I had the final say on any corrective action that was given to him for this act.
Thank you for stating that potential conflict. So I did not hear any objection to adopting. So floor is open for identifying aggravating and mitigating circumstances in this case.
Nick Hunter, Mr. Chair. The aggravating on the criminal charge itself being cited for the DUI and reckless driving.
Matt English, for the record, I actually just have a question for Jennifer for this case. So I see I went back through the police report a couple times and I just didn't see where the reckless driving came in, and my only guess was the DA added that
Correct.
at the time of charging.
Correct.
I just didn't see anything to support that. Thank you.
Was it the speed?
Maybe?
Yeah. That's what I heard.
Mr. Chair, Josh Aldrich for the record. Mitigating circumstance, I believe, is that Mr. Saldana did complete the diversion as directed. I think an aggravating circumstance, I see nowhere including in Mr. Saldana's mitigating statement that he addresses and accepts any responsibility for the driving under the influence. His mitigating circumstances, his written mitigation seems to focus more on what he perceives to be kind of an injustice and an accusation that he did not report this, and I see nowhere that he actually took accountability in anything we've been provided.
Chair English. For the record, on Exhibit A4, see that? Page 2, the information from the DA has the reckless driving as part of the charge.
Any other aggravating or mitigating? Matt English, for the record, aggravating, appears he was employed in public safety when this arrest occurred. Jennifer, could you recount what we have thus far, please?
For mitigating, I have that he's completed his diversion. For aggravating, I have he was employed in public safety when he was arrested. He was cited for DUI and reckless driving. He does not address or accept responsibility for either reporting his information to DPSST in his mitigation.
Thank you. Any further aggravating, mitigating discussion? And unless there's any objection, move that there's consensus around the identified factors. Hearing none, we'll move to discussion and motion to affirm, modify, or negate the moral fitness violations as identified by DPSST, which in this case is misconduct for the criminal charges of DUI and reckless driving and his behavior to threaten to harm people and property.
Ted Langley for the record. I move that we affirm the moral fitness violations as prepared and presented.
Mark Ward for the record, I'll second that.
Thank you.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Chair English,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Warren,
Aye.
Committee Member Bowden,
Aye.
Committee Member Frost,
Aye.
Committee Member Hunter,
Aye.
Committee Member Langley,
Aye.
Committee Member Frasco,
Aye.
Committee Member Reyes,
Aye.
Committee Member Hartford,
Aye.
Committee Member Aldrich,
Aye.
and Committee Member Mace.
Aye.
Motion passed.
Thank you. All right, the floor is now open for a motion to recommend to the board to take action or no action in this case.
Mr. Chair, Nick Hunt, for the record, I'll make a motion that the board take no action in this case. Singular offense. Mr. Saldana has completed everything following that charge that he needed to complete to include the diversion. I will note what was brought up about taking no responsibility for what was there, but I believe the single charge itself and being consistent with other actions taken today, the board should take no action.
Mr. Chair, Josh Aldrich, for the record, I would second that motion.
Thank you. It's been moved and seconded to recommend action.
We are voting on a motion to take no action. Chair English,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Bourne,
Aye.
Committee Member Bowden,
Aye.
Committee Member Frost,
Aye.
Committee Member Hunter,
Aye.
Committee Member Langley,
Aye.
Committee Member Frasco,
Aye.
Committee Member Reyes,
Aye.
Committee Member Hartford,
Aye.
Committee Member Aldrich,
Aye.
and Committee Member Mace.
Aye.
Motion passed.
Thank you. We will move on to our next case, Bonnie Smythe, presented by Jennifer Lavario.
Thank you, Chair English. Jennifer Lavario for the record. The department opened a professional standards case review after Bonnie Smythe was terminated for cause by the Oregon Department of Corrections for inappropriate conduct with adults in custody while on duty. The Department of Corrections found Ms. Smythe to be untruthful during the internal investigation. Ms. Smythe was also found to have utilized DOC computers to show personal pictures and other information to an AIC while on duty. The department's review determined Ms. Smythe also violated the board's moral fitness standards as follows. Ms. Smythe was intentionally dishonest and misleading during the internal investigation into her conduct by DOC with AICs. Ms. Smythe utilized her position as a corrections officer at the DOC to access agency computers with the intent to show pictures and other information about herself and other staff to AICs. Ms. Smythe utilized her position as a corrections officer at the DOC with the intent to develop a personal relationship with an AIC that exceeded the boundaries of a professional relationship. Ms. Smythe caused harm to the efficient operations of the DOC by crossing the professional boundaries of officer-AIC relationships, which also threatened to harm the safety and security of AICs and staff inside the EOCI facility. Ms. Smythe harmed the security of confidential information at the DOC by using agency computers to show AICs personal information about herself and other staff while on duty. Chair English.
Thank you. So if there is no objection, move forward with the with consensus to adopt the record as presented by staff. Not hearing any objections, so we will open the case up for discussion for identification of aggravating and mitigating in this case.
Mr. Go for it.
Ted Langley for the record. Amongst the several examples of untruthfulness, there's also another issue that kind of stuck out to me, and that was the sharing of potentially personal info of people that she worked with, which, for obvious reasons, that's problematic. But not only do we work in a field where the public's trust is vital, but the trust of those that we work beside is vital, and that was a trust that was violated as well. So I list both of those. I mean, there were several examples given of her being untruthful, but then that one as well kind of stuck out to me.
Mr. Chair, Nick Hunter, I would say it's the same concept there, but that an aggravating circumstance is the multitude of provable lies.
Mr. Chair, Aaron Reyes, her allowing the AIC access to department computers is not only a violation of policy, but a threat to the security and safety to the AICs and to the staff, which would be a aggravating factor.
Ted Langley for the record. I'd also point out that, at least for me, the lack of any attempt at mitigation speaks volumes in a case like this. I would list that as an aggravating factor as well.
Lori Frosco for the record. I would state her aggravating as misuse of authority and crossing professional boundaries. And the law, of course, that was one.
Chair, Kathy McAlpine for the record. Just want to let everybody know on the committee that while I understand Chair Langley's concern, we can't weigh in whether or not somebody chooses to exercise their right on providing mitigation, whether it's in person or written. It's their opportunity, but it can't be considered a negative or aggravating at this point.
Nick Hunter, for the record, on the back of what Kathy just said, I think that we can say as an aggravating factor throughout the entire record, there is no record that Ms. Smythe took any accountability for any of her actions.
Mr. Chair, Aaron Reyes for the record. I'd like to add that an adult in custody is not able to consent to a relationship where boundaries are crossed. So she'll think about being taken advantage of her potentially official misconduct using her power and position.
Jennifer, can you recount what we have this morning?
Yeah. I did not hear any mitigating circumstances. For aggravating, I have that the AIC is not able to consent to a relationship where boundaries are crossed. That sharing of personal information, i.e. staff, is a form of dishonesty. Sharing it with AICs. And it's a high priority for those in this situation. It's a safety and security concern. Allowing an AIC to access DOC computers or have any type of access to DOC computers is a violation of safety and security of staff and AICs. Crossing professional boundaries is a misuse of authority. I did want to clarify something, Chair English, in the sharing of personal information. I did hear potentially that this was an additional dishonesty, moral fitness violation. I wanted to clarify whether or not that was what was being said, that this was something that the committee wanted to add, and potentially we're going to get there, but I wasn't certain about that.
Ted Langley, for the record, which statement were you referring to?
When you're talking about sharing personal information with AICs about other staff as being an element of dishonesty that wasn't mentioned in the staff report, my question is, were you thinking that should be an addition in the moral fitness statements?
Ted Langley, for the record, that wasn't my intention of bringing that up. My intention of bringing that up was that I guess I looked at just the moral fitness violation of dishonesty in general. That was at least what stood out to me as just another example that was in all of the information, but my intention wasn't to necessarily have that specific thing added.
Thank you. And that's all I have.
Thank you. Is there any other aggravating mitigating? Unless there's any objections, we'll move forward with consensus surrounding the identified factors. All right, floor is open for a motion to affirm, modify, or negate moral fitness violations as identified by DPSST. Those include dishonesty, misuse of authority, and misconduct.
Jennifer Cameron, I have a question, clarification, in regards to Langley's information. Could that be considered misconduct? Because when individuals share personal information about their coworkers, it potentially creates threats to them outside of work. Is that something that could be added to the misconduct section, since it talks about that? I don't know. If I just need to make a motion, or
Nick Hunter, for the record, it's already in there. If you look under misconduct, it says that harm the security of confidential information by using agency computers to show personal. Oh, maybe I'm wrong. I retract my statement. I actually agree.
About herself and other staff.
yeah.
Yeah.
Okay. Yeah. Just want to clarify. So
Yeah,
I appreciate
no, it's
that.
there.
Thank you.
Yep.
Am I even reading that?
Mr. Chair, I'll make that motion for you that we accept the report as completed and the findings of DPS-S&T.
Thanks.
Mr. Chair, Aaron Rice, for the record, I second his motion.
Thank you.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mace.
Aye.
Motion passed.
Thank you. Floor is open for a motion to recommend to the board to take action or no action in this case.
Jennifer Cameron, for the record, I recommend we take action.
Marta Bowden, for the record, I second.
Thank you.
All right, we are voting on a motion to take action. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mace.
Aye.
Motion passed.
All right. Thank you. So the floor is open for discussion and motion regarding ineligibility periods. This case involves misconduct, misuse of authority, dishonesty, and dishonesty, which is that would be a 3 years to life is what we could recommend up to lifetime. With your motion, please include specifics on why you're recommending that timeline.
Mr. Chair, Nick Hunter, I'll make that motion for you. I would make a motion that we propose a lifetime ineligibility. The aggravating factors, as stated on the record, to highlight a few: one, sharing of confidential information of your coworkers, the multitude of provable lies, and the fact that as far as moral fitness, we have moral fitness violations in all three: dishonesty, misuse of authority, and misconduct. Would support the lifetime ineligibility motion.
Thank you.
Mr. Chair, Aaron Reyes, for the record, I would second that motion due to her egregious behavior, which creates a substantial risk to the safety and security of all within EOCI.
Thank you.
All right, we are voting on a motion for a lifetime ineligibility period. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldridge?
Aye.
And Committee Member Mace.
Aye.
Passed.
Thank you. We'll move on to our next case, Amanda Vincent, presented by Jennifer Varga.
Thank you, Chair English. The Department opened a professional standards review after Amanda Vincent resigned from the Oregon Department of Corrections while under investigation for a Prison Rape Elimination Act, or PREA, violation. Ms. Vincent was engaged in an intimate relationship with an adult in custody while using covert methods to conceal it from her employer. The Department's review determined Ms. Vincent did violate the Board's moral fitness standards as follows. Ms. Vincent intentionally engaged in covert, deceptive communications with an AIC and his family members to conceal the truth about their personal relationship from the DOC and was intentionally deceptive during the DOC internal investigation. Ms. Vincent used her position as a public safety professional with the intent to obtain the benefit of building a personal relationship with an AIC. Ms. Vincent's conduct surrounding her personal relationship with an AIC instigated a PREA investigation which threatened harm to the efficient operations of the DOC by compromising the environment for AICs and therefore the safety and security of the facility. Chair English.
Thank you. Unless there's any objections, move forward that there's consensus to adopt the record as presented by staff. Then the floor is open to discuss aggravating and mitigating factors in this case.
Mr. Chair, Aaron Reyes, for the record, a aggravating factor would be Ms. Vincent violated PREA by using her position to have a relationship with an AIC when he does not have the ability to consent to do so by federal law.
Mr. Chair, Nick Hunter, for the record, aggravating factor is going to be Ms. Vincent's very intentional deception to trying to cover up that relationship that she was engaging in with the AIC.
Ted Langley for the record. I'll take advantage of my new education I just received from the director and just say that I didn't see any materials where that were provided to us where Ms. Vincent was taking any responsibility for any of her actions either.
I second the newfound language that Ted has found to share.
Mr. Chair, Josh Aldrich for the record. Aggravating circumstance is that the adult in custody was provided with contraband items that could pose a risk to the institution and other staff members.
Any additional aggravating?
Mr. Chair, Aaron for the record, I'd like to add as an aggravating factor that her introducing contraband within a secure institution could potentially constitute a criminal act with her behavior and conduct.
Can you read back what we have thus far, please?
I did not hear any mitigating statements. Aggravating statements, introduction of contraband could constitute a criminal act. Ms. Vincent violated PREA by using her position to have a relationship with an AIC who does not have consent to do so. She was intentionally deceptive to try to cover up her relationship with the AIC. She took no accountability for her actions. The AIC was provided contraband which posed a risk to other staff and other AICs and the facility.
Any additional aggravating, mitigating? There are no objections. Say that there is consensus around what has been identified thus far. And we would move to take action or no action in this case.
Chair.
Oh, no, I missed one.
Sorry.
Gotcha. I knew I did. No. So now discussion about the moral fitness violations and accepting what staff has identified in this case. So our the motion can be to affirm, modify, or negate what staff has identified, which is dishonesty, misuse of authority, and misconduct in this case.
Jennifer Cameron, for the record, I move that we affirm the staff report.
Ted Langley for the record.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frosco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mays.
Aye.
Motion passed.
Thank you. Now the floor is open for a recommendation to the board to recommend action or no action in this case.
Ted Langley for the record. I recommend the board we take action.
Lori Frasco for the record. I second.
We are voting on a motion to take action. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frosco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldrich?
Aye.
And Committee Member Mays.
Aye.
Motion passed.
The floor is now open for discussion and recommendation to the board of an ineligibility period for this case. Because it does include dishonesty, we can consider 3 years to lifetime. When you make a motion, please state why you're recommending that length of ineligibility.
Mr. Chair, I would make a motion for a lifetime revocation based specifically on the aggravating factors and with the focus in those areas of deception and the amount of those and the level of deception that she went to try to hide this relationship.
Thank you.
Margaret Wilson, for the record. I second that.
Thank you.
We are voting on a motion for a lifetime ineligibility period. Chair English?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Frasco?
Aye.
Committee Member Reyes?
Aye.
Committee Member Hartford?
Aye.
Committee Member Aldridge?
Aye.
And Committee Member Mays.
Aye.
Motion passed.
Thank you. All right, we will move into agency update. Hearing none.
Chair, Kathy McAlpine for the record, on behalf of the director who had to step out, I will be very brief in my updates. We did want to pass along that preparing for the 25-27 budget, we're doing our policy option package, and what might be of interest to this committee is on there, one of our top priorities is to try and get a learning management system. That's for all of our instruction, both in basic but also in regional. We're very excited about it, but we've also put it in our other packages before. But we're hopeful that it might be a positive outcome. And the other thing is we added a couple of other positions. We've requested to bolster our regional training from our listening tour. We did hear back both on a learning management system need and also to bolster the regional training and maybe do a little bit more collaboration with fire and police. And then also, I don't have the actual date, but we will be adding a basic corrections class in this biennium. Then I'm going to turn over to Kathy Fink for more updates.
Thank you, Kathy Fink. I just want to share with you some of the work the team has been doing in criminal justice, and that's from certifications through professional standards. In June, they held a virtual presentation, which was well attended, and they covered things from scheduling, maintenance, and professional standards. So we bolstered up some more of the professional standards information in the presentations that we have typically done in the past, which was I think it was well needed. Additionally, the team has done, some of the team members have done some outreach to Klamath Tribes Public Safety to help them get established and work through the process of scheduling and hiring and all of our forms. Backtrack just a second, we did update the F4S and the F28 just prior to the virtual training, so we were able to give some additional information to that. And we've recognized that some of our forms need some additional information as far as like what some of the fields and things, so you're going to see some more of that coming out as time progresses. And we have planned a trip out to some additional outreach at Warm Springs PD for the same kinds of things to help them with aspects of scheduling, maintenance, and professional standards that they're looking for some assistance on. And then the other thing is the Moral Fitness Work Group continues to meet, and I think we're down to maybe a guesstimation of 1 or 2 more meetings, maybe. We'll see how it goes. Yeah. Thank you.
And that concludes our updates.
All right, great. Just wanted to thank everybody on the committee for all of your commitment today. It was a really long agenda. Thank you for bearing with me through the new process. I know it was a little clunky. And I also wanted to recognize our 2 new members, Lori and Mike. Welcome, and Thank you for committing to do this.
Thank you.
So our next meeting is November 12th, 10 a.m. Be here, be square. And with that, I will adjourn Corrections Policy Committee.